Hello and welcome back to Moran's vlog series. In my last vlog I talked about the ownership challenges posed by private trust companies or PTCs. In this vlog I'll talk about some of the issues in relation to the PTC's board of directors. If you need a reminder of what a PTC is, take a look at my last vlog first, then come back to this one. It matters hugely who's on the board of a PTC because the board will be able to make all of the decisions about the management of the wealth in the trusts of which the PTC is the trustee. This includes things like how the trust assets are invested and who gets a distribution and when. The way those decisions are made and the people who make them can have a major role in helping maintain harmony within the family if they get it right. If they get it wrong, however, they can potentially destroy that harmony with all the consequent risks that go with that, including family divisions and, at worst, litigation within the family. This means that whenever a PTC is proposed, it's vital to give some thought as to who should control it over the long term. For PTCs, there's also a very important nuance which is often lost sight of, namely the fact that the PTC is acting as a trustee of family trusts. So when it comes to making decisions, those decisions are fiduciary ones which, if they do not respect the trustee's fiduciary duties, can potentially be challenged by the beneficiaries in the future. To illustrate this, let's imagine that you have a PTC with a sole or controlling director. Let's say it's the patriarch or matriarch of the family who's the settlor of the trusts. That director might easily fall into the trap of concluding that by being the sole or controlling director, that gives them the ability to make any decision they like in relation to the trusts, however they like, as if the assets of the trusts were their own. But of course, that would be a mistake. The decision of a PTC as trustee of the trusts is just as susceptible to challenge as any other type of trustee. It's very important that the director understands that point to avoid making poor trustee decisions, and there is therefore a serious need for education about trust law for any layperson who is considering becoming a director of a PTC. Moreover, if the settlor wants to have powers in respect of the trust assets that he or she can exercise having regard only to their own interests, then the robust way to achieve that is by retaining personal powers, such as powers to revoke or to give directions, under the terms of the trusts themselves. Aside from a proper understanding of trusts, any person who is a director of a PTC should have a good grasp of corporate governance. Very often, there won't be a sole director of the PTC. Indeed, it would usually be a bad idea to have a sole director because of the risk of the director becoming incapacitated or dying, leaving the affairs of the trusts paralysed until other directors can be appointed. Frequently, there will be a mixed board of directors comprising the settlor or other family members or its close advisors on the one hand and one or more representatives of the trust and company services provider that administers the PTC on the other. Having professionals on the board can be very helpful, especially where the family is not experienced with trusts and trustee decision making. The board of directors should practice good corporate governance and, in particular, by making decisions through properly convened meetings of the board at which there is all relevant information shared with the attendees and the opportunity for discussion. If corporate governance is ignored, then the decisions of the PTC can become susceptible to challenge in the future. There is also the prospect of personal liability of directors. The risk of personal liability is also something that any family member, or indeed anyone else, should consider when deciding to be on the board of a PTC. Normally, the directors of a PTC don't have personal responsibility for the acts of the PTC, but in extreme cases, for example, willful breaches of trust, that personal responsibility can't be ruled out. There's also a broader issue going further than just liability for acting as a director, and that's to do with the responsibility that any family member on the board of the PTC will no doubt feel to other family members who are not. Obviously, if the affairs of the trust go badly, whether or not through mismanagement, for example, if a trust investment representing a significant portion of the family's wealth suffers a large loss, it would not be surprising for that to cause tensions within the family, directed at those who were on the board who made the investment decisions. That risk is in effect the flip side of the coin that has control on its other side. By this I mean, if you want to be in control of decisions by being on the board of a PTC, you may be the person on the receiving end of complaints from the rest of the family. Compare that to the situation where a professional trustee is used, where the family have less control, but where, if things go wrong, it's the professional trustee that is more likely to have responsibility. That's a rather glass half empty way of looking at PTCs, and of course things often don't go wrong, but it's sometimes something to be aware of. When working out how best to deal with control in a PTC structure, it's also important to bear in mind the other objectives that settlors usually have when creating trusts. This includes asset protection and tax. When it comes to asset protection, it can be important to ensure that the trusts are not made vulnerable to attacks by third parties by conferring too much control on the settlor, and that includes control obtained through involvement in a PTC. Now, tax is a whole other subject and one where onshore counsel should be consulted. Thank you so much for watching this vlog, and please watch out for further updates from us over the coming months.